We now go to Canon 5, equality. Canon 5, equality. Every lawyer shall adhere to the principle of equality and hold firmly the belief that every person, regardless of nationality or ethnicity, color, sexual orientation, or gender identity, religion, disability, age, marital status, social or economic status, and other like circumstances, has the fundamental right to equal treatment and representation. As such, the lawyer shall accord equal respect, attention, dedication, and zeal in advancing the client's cause, regardless of the personal opinion, religious, or political beliefs pertaining on the personal circumstances of the client, except for justifiable reasons. So, when I practice as a lawyer and somebody comes to me, for example, born-again Christian will come to me, I cannot refuse and say I cannot defend you because you're a born-again Christian. I will be liable under Canon 5 on equality. I will refuse because I cannot take anymore because I have lots of cases already in my hands. But never will I say, no, because I am a Catholic and you have a different religion, I will not handle that. No, that's a big, big no. Okay? That's not a valid recusal. And I can even be held liable under Canon 5 on equality. Okay, we now go to Section 1 of Canon 5, Non-discrimination. A lawyer shall not decline to represent a person solely on account of the latter's nationality, ethnicity, sexual orientation, or gender identity, religion, disability, age, marital status, social or economic status, political beliefs, or such lawyers or the public's opinion regarding the guilt of said person, except for justifiable reasons. This Cpra provision is also found in two provisions of the old code, specifically Rules 14.01 and Rule 2.01. Rule 14.01 says, a lawyer shall not decline to represent a person solely on account of the latter's race, sex, creed, or status of life, or because of his own opinion regarding the guilt of said person. In Rule 2.01, it says, a lawyer shall not reject, except for valid reasons, the cause of the defenseless or of the oppressed. Section 2. Treatment of vulnerable persons. In dealing with a client who belongs to a vulnerable sector, a lawyer shall be mindful and sensitive of and consider the client's special circumstances as well as the applicable laws and rules. The lawyer shall observe higher standard of service suited to the particular needs of the vulnerable person and shall assert such person's right to meaningful access to justice. Take note of this section because in the quiz, I might ask you where in the Cpra you will find the line in the lawyer's oath that says access to justice. Your answer will, of course, be Section 2 of Canon 5 of the Cpra. Still on Section 2, treatment of vulnerable persons, a vulnerable person is a person who is at a higher risk of harm than others and shall include children, elderly, homeless persons with disability, persons deprived of liberty, human rights victims, victims of domestic violence, victims of armed conflict, those who are socio-economically disadvantaged, those who belong to racial or ethnic minorities, or those with debilitating physical or mental conditions. Section 3, indigent person. A lawyer shall not refuse the representation of an indigent person except if A, the lawyer is not in a position to carry out the work effectively or competently due to a justifiable cause. Letter B, the lawyer shall be placed in a conflict of interest situation, or C, the lawyer is related to the potential adverse party within the 6th degree of consanguinity or affinity, or to the adverse counsel within the 4th degree. This is also found in Rule 14.03 of the old code, the CPR, that says, a lawyer may not refuse to accept representation of an indigent client unless A, he is not in a position to carry out a work effectively or competently, B, he labors under a conflict of interest between him and the prospective client or between the present client and the prospective client. An indigent is any person who has no money or property sufficient for food, shelter, and other basic necessities for oneself and one's family. There's really a case about this. You might refer yourselves to Spouses Algura versus City of Naga. This is also found in Rule 3, Section 21 of the Rules of Court. Indigent party, a party may be authorized to litigate his action, claim or defense as an indigent if the court, upon an ex parte application and hearing, is satisfied that the party is one who has no money or property sufficient and available for food, shelter, and basic necessities for himself and his family. Such authority shall include an exemption from payment of docket and other lawful fees and payment for transcriptions or stenographic notes, which the court may order to be furnished to him. The amount of the docket and other lawful fees which the indigent was exempted from paying shall be alien on any judgment rendered in the case favorable to the indigent unless the court otherwise provides. So you see, the court is also trying its best to recoup what it lost by giving the privilege to the indigent, because any judgment rendered, what the court missed because of granting the exemption to the indigent, the court will just charge to the losing party. Section 3, still on indigent person. Any adverse party may contest the grant of such authority at any time before judgment is rendered by the trial court. If the court should determine, after hearing, that the party declared as an indigent is, in fact, a person with sufficient income or property, the proper docket and other lawful fees shall be assessed and collected by the clerk of court. If payment is not made within the time fixed by the court, execution shall issue or the payment thereof without prejudice to such other sanctions as the court may impose. So take note here of this important commentary, that the adverse party who would like to question the grant of such authority to an indigent client not to pay the docket fees and other fees, he must contest it anytime, but before judgment is rendered. So you have all the opportunity as the case progresses, but make sure you contest the grant to the indigent person before judgment is rendered by the court. Let's check Rule 141, Section 18 of the Rules of Court on indigent litigants. Indigent litigants exempt from payment of legal fees. Okay. A, who are these indigent litigants? A, this is according to the rules of court, whose gross income and that of their immediate family do not exceed 4,000 pesos a month if residing in Metro Manila, 3,000 pesos a month if residing outside Metro Manila. And letter B, who do not own real property with an assessed value of more than 50,000 pesos, they shall be exempt from the payment of legal fees. So take note of the parameter with which the court will diagnose whether or not the client is really indigent. The legal fee shall be alien on any judgment rendered in the case favorable to the indigent litigant, unless the court otherwise provides. To be entitled to the exemption herein provided, the litigant shall execute an affidavit that he and his immediate family do not earn a gross income above mentioned, nor they own any real property with the assessed value aforementioned, supported by an affidavit of a disinterested person attesting to the truth of the litigant's affidavit. Any falsity in the affidavit of a litigant or disinterested person shall be sufficient cause to strike out the pleading of that party without prejudice to whatever criminal liability may have been incurred. And mind you, if you are the disinterested person vouching for the veracity of the economic status of the litigant, you can also be held liable for misleading the court. And take note of the amounts. It has to be indicated. Take note of the amounts. These have to be indicated in the affidavit. In Metro Manila, the income of him and the immediate family should not be beyond 4,000 per month. If living outside Metro Manila, 3,000 per month of aggregate salary of him and his immediate family. Section 4, standard of service. A lawyer shall observe the same standard of service for all clients regardless of remuneration, except for the higher standard required for representation of vulnerable persons. This is found also in Rule 14.04 of the Cpra. A lawyer who accepts the cost of a person unable to pay his professional fees shall observe the same standard of conducting, governing his relations with paying clients. So take note of Section 4 because Section 4 makes an exception except for the higher standard required for representation of vulnerable persons. And the higher standard is justified because you're representing a vulnerable person in society.